If your entire future plan is F1 to OPT to H-1B, and your feed is suddenly full of posts saying the March 2026 H-1B lottery is now pay to play, that there is a $100,000 fee wall for overseas hires, that USCIS is denying people over memes, and that travel for stamping could trap you outside the US until 2027, take a breath. The truth is, some of these claims are possible in theory. Some are misunderstandings, and some are the kind of internet telephone game that spreads because everyone is stressed. By the end of this video, you will have 3 things. First, a clear separation of what is verified versus what is only being reported or speculated. Second, a simple way to think about your risk level if you are level 1 entry level versus higher wage, and what you can actually control. And third, a practical checklist you can start today to protect your status, your job search, and your H-1B filing, even if rules change late. Now here is the part most people miss. Your plan cannot be based on one viral thread. The H-1B system has multiple choke points: the registration process, the specialty occupation evidence, the employer relationship, and then later, travel and visa stamping. Even if the lottery stays random, people still get stuck at the RFE stage. And even if the RFE stage goes smoothly, people still get stuck at stamping. So we are going to walk through this like a risk map. Let us start with what changed, or what people are claiming changed. The idea floating around is that the random lottery is dead, and your odds are tied to your wage level. People describe it like this: level 1 gets 1 entry, level 4 gets 4 entries. So higher salary means more chances. That is a very specific mechanism. And when a claim is that specific, your first move should be to ask, has USCIS actually published that as a final rule, a policy update, or official cap season guidance? If you cannot point to an official USCIS page or Federal Register publication, treat it as unconfirmed. That does not mean you ignore it. It means you plan in a way that does not require the rumor to be true. Because even without an official pay-to-play lottery, wage level still matters in real life. It affects whether an employer is willing to sponsor you, whether the job looks credible for specialty occupation, and whether the overall petition feels consistent. Microhook. This is where people get denied, not at the lottery, but later when the story does not add up. So what are wage levels anyway, in plain English? In the H-1B context, employers use prevailing wage data for a job in a specific location, and wage levels are often described from level 1 to level 4. Level 1 usually means entry level. Level 4 is more experienced. A higher wage can signal a more complex role, but it does not automatically make a job a specialty occupation, and it does not automatically make a petition approvable. Here is a myth versus reality moment. Myth: if you are level 1, you are doomed. Reality: level 1 petitions can be approved, especially when the job description, degree requirement, and supervision structure are well documented. What has changed over time is how closely some cases are scrutinized and how much evidence is needed. Now, who would be affected if a wage-weighted selection system actually happened? First bucket, F1 students on OPT or STEM OPT trying to get selected in the cap season. If selection favored higher wages, then very new grads in lower-paying roles could be at higher risk of not being selected. Second bucket, employers who historically filed many entry-level petitions might change their strategy, hire fewer entry-level candidates, or push candidates into higher title and higher pay if business allows. Third bucket, candidates abroad would still be impacted because they compete for the same cap numbers in most cases, who might not be affected as much. People going through cap-exempt pathways, for example, certain jobs with cap-exempt employers, or individuals who already have an H-1B and are doing extensions or amendments. But do not assume you are cap-exempt just because you are at a university. Cap-exempt is about the employer type and the role, not simply about being smart or having a degree. Bridge hook. 2 groups are at highest risk if rules shift late: new grads with short work authorization timelines and employers who wait until the last minute. Next spicy claim, the so-called $100,000 invisible wall for overseas hires. The way this is framed online is that a new large fee applies to overseas hires, but people already in the US, like F1 students, are exempt, making them a bargain hire. Here is how to treat this kind of claim responsibly. Fees can change, and Congress or agencies can create or raise certain fees, but a specific number and a specific exemption category should be treated as unconfirmed unless there is official documentation. However, the underlying dynamic is real even without that exact fee. Employers think about total cost and risk. Someone already working for them on OPT is a known quantity, already onboarded, often already in the US, and sometimes easier to transition than recruiting overseas and dealing with relocation, consular processing, and uncertainty. So the practical takeaway for F1 viewers is not to celebrate a rumored fee. It is to understand your value proposition. You reduce friction. Your job is to make it easy for the employer to say yes. Here is the small detail that changes everything. Cost is not only money, cost is time, paperwork, and the chance of disruption. Now the social media background check claim. People are saying USCIS is deep diving your digital footprint, and one meme can get you denied for being anti-American. Let us separate what is plausible from what is exaggerated. It is plausible that government agencies review publicly available information in some cases, especially in security-related contexts. And it is also true that visa applications and certain forms may ask for social media identifiers in some scenarios. But for an H-1B petition, the core decision is typically about the job, the employer, and eligibility, not about your jokes on TikTok. Still, do not be careless. The real risk is not that a spicy meme automatically triggers an instant denial. The real risk is inconsistency or credibility issues. Posts that contradict what is in your petition, posts that suggest unauthorized work, misrepresentation, or other red flags. Another risk is that a consular officer at the visa stamping stage has broad discretion to ask questions and evaluate credibility. So the practical advice is simple. Keep your public footprint professional, do not post things that imply you are working without authorization, and do not lie on forms. Myth versus reality. Myth: you must delete all your social media to be safe. Reality: deleting everything right before an interview can look odd, and you cannot erase screenshots. A better approach is to audit your privacy settings, remove posts that clearly create risk, and most importantly, do not create new problems. Bridge hook. If you only fix one thing after this video, fix your consistency. Your resume, LinkedIn, job title, and petition story should match. Next claim: Texas and Florida blacklist. Public universities are out of the sponsorship game. This one needs careful framing. Different states and public institutions can have their own employment restrictions, funding rules, or contracting policies that affect what positions they can offer and how they can hire. But it is a big leap from that to a blanket statement that public universities are officially out of sponsorship. So what should you do if you are a PhD student, postdoc, or researcher at a public university in any state and you rely on that institution for your immigration plan? Do not rely on viral summaries. Ask your department administrator and HR, ask your international office, and ask specifically, will the institution file H-1B for my position? Is the position cap exempt? And what are the internal timelines? Some universities file H-1Bs routinely. Some positions are funded in ways that create constraints. The reality is often local and administrative, not a statewide blacklist. Here is the part most people miss. Even if your university can sponsor, the timing might not match your OPT end date. University timelines can be slow. If you are waiting, you can fall out of work authorization. Now, the stamping trap claim: do not leave the US. If you go to India or Mexico for stamping, you might be stuck until 2027 because consular slots are disappearing. There is a real concept here. Visa stamping is separate from H-1B approval. If you change status inside the US and later travel, you typically need an H-1B visa stamp to return, unless you have another valid visa and qualify for specific exceptions. Consular appointment availability can be tight and can vary by country and time of year. Administrative processing can add delays. What we cannot do is promise a specific year like 2027 for everyone. That kind of timeline depends on the consulate, the season, and individual case factors. But the risk management principle is valid. Do not travel casually during sensitive periods. If you are going to need stamping, plan it like a project. Check appointment availability early, understand what documents you will need, and have a backup plan if delays happen. Bridge hook. The biggest travel mistake is assuming approval equals re-entry. They are different steps. Now, the RFE fever claim: USCIS is issuing requests for evidence for specialty occupation like candy, especially if your job title does not perfectly match your degree. This is closer to a realistic pain point many people experience. An RFE is not a denial. It is USCIS saying, we need more evidence. But RFEs can be stressful because they are time-sensitive, they can delay work authorization in some contexts, and a weak response can lead to denial. The specialty occupation issue, in plain English, is this. USCIS wants to see that the job normally requires at least a bachelor's degree in a specific specialty, and that your degree is related. Problems arise when the job description sounds generic, when the degree requirement sounds too broad, or when the wage level, duties, and supervision do not match the claimed complexity. Myth versus reality. Myth: if your title is analyst, you are automatically denied. Reality: titles are less important than duties, requirements, and how the role is structured. A software engineer can be weak if the description is vague. A data analyst can be strong if the duties are specialized and the degree requirement is specific. So why might all these trends be happening, even if some details are overstated? A few reasons. 1. Demand. The H-1B cap is limited and demand is high, so the system is under pressure every year. 2. Enforcement trends. Agencies can increase scrutiny, and employers and beneficiaries have to meet the burden of proof. 3. Backlog mechanics. Processing delays, staffing, and policy shifts can change how fast cases move and how predictable timelines feel. And 4. Timing. When you are an F1 student, your work authorization clock is real. OPT has an end date. STEM OPT has reporting requirements and deadlines. When something goes wrong, you do not have unlimited time to fix it. Bridge hook. A small paperwork mismatch can cost months, and months are what F1 to H-1B plans do not have. Let us talk real-world consequences with 2 example scenarios. Example scenario 1, entry-level new grad, level 1 wage. You graduate in May. You start OPT in July. Your employer likes you but pays entry-level wages. They want to register you for the cap. If selection becomes wage-weighted, your odds could be worse. But even if nothing changes in selection, you could still face risk if your role is loosely defined or if your degree and duties do not line up cleanly. Your best move is to work with your manager early to clarify duties, tools, projects, and why the role requires your specific degree. You also need to track your OPT unemployment days and keep your SEVIS reporting perfect. Example scenario 2, higher wage, level 3 or 4. You have 2 years of experience on STEM OPT, you are leading a small project, and your employer pays more. Your selection odds might be better if any wage weighting exists, but your bigger risk may be travel. You get selected, your change of status is approved, and you plan a quick trip home for a wedding. If you cannot get a stamping appointment or administrative processing hits, you could miss your start date and create a crisis at work. Now, what should you do right now? Here is a practical do this. Avoid this checklist that works whether the viral claims are true or not. Do this. Build a clean evidence file. Keep a folder with your transcripts, diploma, course descriptions if relevant, updated resume, offer letter, and a clear job description that matches what you actually do. Avoid this. Letting your LinkedIn and resume drift away from your real job duties or your employer paperwork. Do this. Align your story. Your job title, duties, salary, and degree should form one coherent narrative. Avoid this. Last-minute title changes that look like they were only done to game a system. Do this. Talk to your employer early about cap season planning. Ask when they will do registration, who the attorney is, and what documents they need from you. Avoid this. Assuming HR knows your timeline or that they will remember deadlines. Do this. Understand wage level without obsessing. If you are concerned about being level 1, focus on real career moves, building specialized skills, documenting complexity, earning certifications that match the job, and negotiating fairly when possible. Avoid this, believing you can fix everything by chasing a number. Salary alone does not prove specialty occupation. Do this. Treat travel as a risk decision. If you might need stamping, check consular appointment patterns early and plan for delays. Avoid this. Leaving the U.S. right after a change of status approval without understanding re-entry requirements. Do this. Keep your F1 compliance perfect until you are truly in H-1B status. That means STEM OPT reports on time, correct employer details, and no unauthorized work. Avoid this. Informal side gigs, cash work, or anything that could be interpreted as unauthorized employment. Do this. Monitor only official sources for rule changes. USCIS announcements, official guidance pages, and reputable law firm alerts that cite official documents. Avoid this, making irreversible decisions based solely on social media posts. Bridge hook. If a rule really changes, you will see it in official guidance. If you do not, treat it as noise. Now, what should you watch next between now and March 2026? First, watch for official USCIS updates about the CAP season process, including whether registration selection changes, fee changes, or evidence standards change. Second, watch for State Department signals about consular appointment availability, because stamping delays can hit even approved cases. Third, watch your own timeline. When does your OPT end? Are you eligible for STEM OPT? And what is your backup if you are not selected? Backup planning is not pessimism, it is survival. That could mean exploring CAP-exempt options if you qualify, considering further study if it fits your career, looking at other work-authorized pathways your employer might support, or planning for a compliant departure if needed. The right backup depends on your situation, and you should verify with qualified help. Myth versus reality. Myth: if you are not selected once, your U.S. career is over. Reality: people regroup. Some move to CAP-exempt roles, some re-register next season, some build experience abroad and return, and some switch to different compliant options. The key is staying in status and making decisions early. Let us close with a calm recap. 1. Treat March 2026 viral claims as unconfirmed until you can tie them to official USCIS publication. 2. Wage level can matter for the overall credibility of a petition, but it is not the only factor, and you can strengthen your case with clear duties, degree alignment, and documentation. 3. Do not underestimate stamping risk. Approval and re-entry are different steps. 4. Expect scrutiny on specialty occupation and be ready for an RFE with organized evidence. 5. Protect your status first. Perfect F1 compliance, early employer planning, and a realistic backup plan. Do not panic, but do not drift either. If you want, comment with your situation in broad terms like F1 OPT, STEM OPT, job field, and whether your employer is CAP subject or CAP exempt, and I will cover the most common scenarios in a follow-up. And if this kind of practical, non-hype immigration planning is helpful, subscribe and turn on notifications so you do not miss the next update when real guidance drops.